Against no. The ayes have it. Clerk.
Government business. Order of the day. Telecommunications Interception and Access Amendment Data Retention Bill 2014. Resumption of debate on second reading and on the amendment moved by Senator Ludlam.
Senator Ludwig.
Thank you, Acting Deputy President. I rise to speak on the Data Retention Bill. First, I'd also like to note that at the outset of this bill, it's invaluably complex, and particularly the provisions of the data retention scheme have been examined, a number of factors which have been considered by various committees, and amendments have now been made to this bill, which is before the Senate today. So I'll try to bring my remarks to include where we are today with the bill. The bill differs, as I indicated, greatly from the original bill introduced by the government, but for some background, the proposal for this bill is to introduce a mandatory data retention scheme which was explored in the Parliamentary Joint Committee on Intelligence and Security in its 2013 report of the inquiry into potential reforms of Australia's national security legislation. At over 300 pages, the PJCIS report provides extensive analysis of and commentary on the bill and the proposed scheme generally. Some of the key concerns raised by the PJCIS about the bill include the appropriateness of using regulations to specify the definition of the scope of data that must be retained, expand the category of services that will be subject to the data retention obligations, and expand the number of criminal law enforcement and enforcement agencies that can access the retained metadata, the length of time metadata is to be retained, the cost of the scheme, access to and use of retained metadata by civil litigants, the application of the Privacy Act of 1988 to all service providers covered by the scheme, the application of the scheme to offshore and over-the-top providers, ensuring the effectiveness of the scheme is evaluated, using retained metadata to identify journalist sources. This unanimous and bipartisan report by the PJCIS made some total of 38 recommendations, which the government has accepted all of them after what I would only refer to as the assistance of the Labor Party. There has been significant recommendations in the report which provides greater safeguards to the community. But also like to begin these remarks before I go to the detail by reflecting on by Senator Collins' contribution to the second reading debate. Senator Collins observed that Senator Ludlam and the Greens party had launched what could only be described as a deliberately misleading and irresponsible scare campaign against this bill for what is sometimes, I could only consider, their own political purposes, maybe cynical in nature, but certainly for their purpose. A campaign which has been, I think, described by some as hysterical. It's not the language I generally use, Acting Deputy President, but I do think it clouds the proper debate on this bill. It did provoke much excitement from Green senators, and Senator Ludlam indicated that he disagreed with the assessment of his campaign. I share the view that Senator Ludlam's campaign against data retention has been what I would call over the top and not always on facts. Perhaps the best example of Senator Ludlam's hysteria is a rap video that he appeared in regarding data retention. This video claimed that data retention was part of a conspiracy designed to coincide with last year's meeting of the G20 in Brisbane, which the video described as, and I quote, an event at which the captains of the world's most powerful states gathered to plan a planetary fascist, and it goes on, quite in a phrase that I really don't want to go to. But I'm no rapper, but can I say that this video was not entertaining to me in the slightest. The language, I think, was over the top. I would even say at times surprised me that Senator Ludlam would use such language, and Senator Ludlam threatened to go full Gandalf to stop the Parliament passing the Data Retention Bill in reference to a character from a fantasy novel, The Lord of the Rings. It's also not something I would be generally familiar with, but nonetheless, Senator Ludlam is always able to pursue these ways of attracting attention to his particular interest. But I think ultimately it was most undignified way and perhaps even an inelegant production at its best for me to describe it. I acknowledge, though, that Senator Ludlam does take telecommunications interception in a serious way. He has done that throughout many years in this parliament, and it did seem to depart from what I would always call the usual way he's approached these things. We can always depart from the usual path occasionally, and perhaps I can put it down to that in this instance. But I do worry that we then miss the whole debate proper about data retention and the need for it. My own view of this type of political campaigning is that you have to be very, very careful that you don't sacrifice your dignity for the sake of a few votes. But of course, I always leave that for the judgment of individual senators in this place to decide. And of course, other elements I won't go into of Senator Ludlam, only is to say that I would add that Senator Collins has provided a note of congratulations to Mr David Spears for his Walkley Award-winning interrogation of Senator Brandis in relation to metadata. That I did find extremely abusing from Labor's perspective. It was reported on the Sky News website today that Mr Spears has been nominated for a Gold Logie for this interview. As Senator Collins noted, this interview was not the high watermark of public policy. Indeed, it has been variously described as a train wreck, and embarrassing and humiliating, but it was a fine example of good journalism in action, and I joined with Senator Collins in congratulating Mr Spears on his achievements. So, to be fair, in this place, I have, yes, criticised perhaps what Mr Ludlam, what Senator Ludlam might say is unfair, but also the person who's brought this legislation forward. Perhaps if it had been made in a much more considered way, we wouldn't have had a report which required so many amendments that the government then had to accept. Why? Because it was a significant improvement to the legislation in truth. And the committee made a substantive number of recommendations. I won't go into them all in the time available, but it did provide a vastly better bill. The reality is, of course, the opposition to this bill, I think, has been unjustified. One of the examples, I think, is where the Greens, I worry, don't support any retention of any metadata, even the existing arrangements. And I think that colour came through, not because, in this instance, it will put regulations and safeguard to the collection and retention of metadata, but because they simply don't support this type of legislation in any shape or form. What, of course, astounded me the most was not the video, but the Abbott government and the Attorney-General, Senator Brandis, throughout this bill as originally introduced, did not take sufficient, I think, seriousness the safeguards that needed to be put in place to ensure it was effective and would garner the support of the Senate. The original version of this bill was severely lacking. The protections that the community and business would have expected. The bill gave a disproportionate amount of power to the Attorney-General to make decisions with no parliamentary oversight. It placed fundamental provisions into regulations instead of the primary legislation and provided no protection to journalists or their sources. It showed what a lack of thought was given to the privacy of our citizens and the integrity and freedom of the media in the introduction of the bill in its original form. It's only thanks to Labor and our members of the PJCIS that pursued these common-sense, important and numerous amendments to the legislation that it is a bill that strikes the right balance between ensuring that there is sufficient tools available to our enforcement agencies and privacy protections. The requirements of a journalist information warrant was rejected by the government initially, but after a sustained public campaign, the Abbott government did finally succumb to reason and common sense and included the warrant provisions. Our law enforcement and national security agencies should have the power they need to protect Australia from the threats of crime and terrorism. However, we also believe in the importance of protecting the fundamental freedoms that define Australia as a democratic nation. It is critical that we get the balance right between keeping people safe and protecting our civil liberties. There is nothing new about the collection of metadata. It has occurred for many years and it has been accessed by government agencies for many years with insufficient safeguards to protect personal privacy. Data being collected in huge volumes in an unregulated manner is what this bill aims to remedy. The bill in fact aims to provide more security and confidence to the community about the reasons for and the manner in which this data can be accessed. It puts greater burden on the government agencies to prove the need for this information. This data has been accessed by many dozens of federal and state territory agencies, including local councils, and it does beg that we do require sufficient safeguards to ensure this legislation meets and demands the protection of personal privacy. Labor's approach to this bill is an opportunity to regulate and improve the use of data for law enforcement and counter-terrorism purposes, while at the same time, Acting Deputy President, introducing safeguards that will greatly improve the transparency and accountability of storage and access to that data. We cannot overlook the fact that access to metadata is vital to the work of our law enforcement and national security agencies. The bill was introduced into Parliament late last year. It was inadequate at that time. In particular, the safeguards were insufficient. We made sure, that is Labor, that the bill will be sent to the Parliamentary Joint Committee on Intelligence and Security for proper scrutiny and to allow the public to have their input into the bill. As a result, the government has accepted many amendments to improve the bill to better balance the importance of upholding fundamental democratic freedoms with national security concerns addressed. In particular, Labor believes that freedom of the press is one of the most fundamental elements of our democracy, and we will always continue to argue for its protection. Labor forced the Abbott government to accept a regime where it will be illegal for agencies to access metadata for the purposes of identifying a journalist's source unless they first obtain a warrant from a court. Agencies will be prohibited from accessing metadata to identify a journalist's source unless they obtain a journalist's information warrant. And consistently with other warrants under the TIA Act, law enforcement agencies will seek warrants from a judge or a AAT member. Asia will seek warrants from the Attorney-General. There will be a presumption against the issuing of the warrant, and agencies must prove that the public interest in issuing the warrant outweighs the public interest in protecting the confidentiality of the identity of the journalist's source and having regard to, among other things, the importance of personal privacy, whether the agency has made reasonable attempts to obtain the information sought by other means, the importance of the matter being investigated, the extent to which The metadata sought would assist that investigation and any submissions made by the public interest advocate. There will always be a presumption against issuing the warrant, and agencies will need to prove that the public interest in obtaining the information sought under the warrant outweighs the public interest in protecting journalist sources, which is essential to the freedom of the press.
Have you concluded your remarks? Thank you, Senator Ludwig.